Hi, everyone. It's Grant Abbott. I've got Mr. Tim. How are you going, Tim?
I'm good, thanks, Grant. Hi, everyone. Great to see everyone online again. Looking forward to this deep dive into trusts.
Yeah, it is. So a lot of it came out of that Trust Deed Awareness Week. And, you know, from that perspective, I think we've all gone bubbling along. And what I'm doing now is I'm really going to start. So, again, the good thing is we haven't got a huge amount of people here. We've got, 60 or 70, which is great, which would be a lot of our advisors, but we're going to start to go and do a really hardcore deep dive, and I'm going to show you what a trust to use at what time, the differences there, so you have a really good understanding. So hopefully it'll make a big difference. But Michael, I mean, I know you do a lot of work at Vendum Optimum through, in fact, there's one I didn't put in the trust, employee share plans, which are based on essentially a trust that we developed in terms of a unitised style trust, but also with potential hybrid natures for the employee share plans. So that seems to be going extremely well, doesn't it, Mike?
It does, yeah. It's fantastic. So it's a lot of strong demand for it, which is good to see.
Yeah, well, I think the structure we've got there, which is really, it's almost a hybrid between a retirement fund, not a retirement fund, an employee fund, and also obviously a trust or a unit trust style thing. So there's some really good opportunities, and there's a whole lot that's coming out. I know Tim sent me through a couple of things the other day around the main residence trust, but we're gonna start to build things out of there. And for those of you who haven't met, what you can see over in Philippines, we've got Anusa who looks after all our events. She put a mic on, but she's subject to a whole lot of noise there over in the Philippines. So watch out, President Duterte, he'll probably burst through the door in a second, who knows. So
it's fantastic. Anusa's got, I know my partner webinars are organised for the next 5 or 6 at the moment. She's been sending invites out, and usually I'm the week before, we were just talking about putting slides together and everything. I'm trying to rush and organise who I'm going to have on and what we're going to do, and so it's
good. Well, put you on, yeah. So you were very lucky. We've got a fantastic team.
Now, well, that's looks like she's in the Matrix,
Yeah, we've got the Matrix again. Exactly.
The Matrix.
It looks like the Matrix, doesn't it? Just waiting for the code to come. So yeah, you never know. But you'll always hear me do this. You'll always get me to see this slide because I think it's really important for us to be open to new ideas. And look, again, if you had a look at the use of the trust from a structural point of view, you'd have to say every accountant can set up a trust, every lawyer can set up a trust. So it's well and truly down at that laggard section. So it's not as if it's new. But when you come around to do a leading member or a family protection trust, quite clearly you're down at that early adoption phase there. SMSF Death Benefits Trust, early adoption. In fact, I had a very funny one when I first talked about it. It was, I had a good friend of mine who said, I was talking about the benefits of doing one of these SMSF Death Benefits Trusts, which is like a testamentary trust that's got concessional rates for minors, but it flows out, and you'll see it flows out of an SMSF will and comes by the trustee of the SMSF actually settles that trust. So it's completely different to one from the estate. But I had a couple of lawyers coming in and saying, someone wrote me an email, said, you can't do this, it's against the law. I said, well, it's not. You obviously just haven't read the laws. So again, we're in that space, that innovation and early adoption. And to be really honest, as we go forward from this, and many of you have become part of SEPEPA, and SEPEPA will be launching foundation memberships and ordinary memberships very shortly. We've had 115 people go through the course, which is fantastic. So they'll be the first set of advisors, and everyone's done extremely well in the assessments and examinations. So we're in a really good position there. But again, over time, that's the stuff that we're doing is going to go from early adopters into that early majority, and finally it'll go down to the late majority there. So again, just when you look at yourself with this, where do you find yourself in this whole process? And I think that's crucial. One thing I do know, and I would go back to what Michael was saying, is for those of you who are early adopters, you're the ones who've actually read the deeds. And I can tell because people come and say, well, hold on, maybe, and I'll show you a bit later on, maybe you should put in a definition of bloodline, which I just thought would use the common law term, but it makes sense. So I'll show you the new definition. We've got a bloodline that's coming down the track, and you'll keep on pushing us down to this. So we have the early adopters who are the smarties, who do the review, look at the laws, look at the rules, look at the deed, and then they push it to us, who are the innovators who actually draft up the stuff to actually then release a product that then goes back to the early adopters. So it's a benefit of all. And you've heard us talk about that Kaizen principle that, small, continuous, ongoing change improves the lot of all, so that we get the feedback from here going in there and comes back. Now, I can tell also when I get on the phone with people, whether they're laggards or not. So, you get on the phone, you'll soon find out whether the person's a laggard. And then that's a completely different position, because you have to take them right back to the basics. So anyway, let's move on. This is a bit of a long one. I actually got this from a blog, and I was going to draft up something myself, but I thought, what I'll do is I'll just take this out. This is from Tax Fitness, which is a group of a business group that looks after, I think, about 90 or 100 accounting firms. But the Romans developed the first trust, fidecommissum, so that's obviously Latin. I did actually Latin for 1 year at school because I wanted to be a doctor. Can you believe that? Which were testamentary trusts created by wills. The first living trust, inter vivos, so you'll hear a lot about that, because the space we're going down, that early adoption innovation space, is that living trust, those inter vivos trusts, were developed in England during the 12th century Crusades. When a landowner left England to fight in the Crusades, he conveyed ownership of his lands in his absence to manage the estate and pay and receive feudal dues on the understanding the ownership would be conveyed back on his return. However, Crusaders often encountered refusal to hand over the property upon their return. And unfortunately, English common law did not recognise the Crusaders' claim. So what we had, that's quite that one point we're going back to, as I said, the 12th century, because they didn't know that they were going to come back alive. In fact, there's probably a good chance that they weren't. They handed it off to a friend or a brother or whatever who held it there for them. There was no concept of the trust. Now, what would happen? They come back and the other person say, well, hard luck, it's my property. I've got the legal title. But then what happened is this whole body of law of equity came in, that the unhappy crusader would then petition the king, who would refer the matter to his Lord Chancellor, who would then, and this is important, decide a case according to his conscience, which is fairness. The Lord Chancellor considered it unconscionable that the legal owner could go back on his word and deny the claims of crusader, which is fair enough. Therefore, he would find in favour of the returning crusader, and the Court of Chancery, which is an equity court, would continue to recognise the claim of returning crusader. And from this developed what we know as trusts. So, the basic trust we do it all the time. Michael, can you mind the car for me? Can you mind my dog for me? Can you do that? That's a trusting relationship. And again, out of that, the common law or statute law, to a certain extent, we've got another side of law called equity, and that for us is fairly important and really impinges on all of us, because we're all subject to, obviously, trust law, duty of care. Many of you have heard of that. That's under the law of torts, and the old snail case. I forget what the snail case is. It's something McPherson. But we've also got, obviously, the law of negligence that comes out of that law of tort, which is a duty of care in terms of advising clients. So trusts are not exactly fly by night, but there's obviously they've done extremely well. Companies weren't first set up until the 17th century over in the Netherlands or in Holland, as it was in those days. So we've got a body of law that the trusts have been, again, way back to the Romans, have really stood the test of time for many centuries, as opposed to companies which are relatively new, SMSFs, which are in fact trusts, really, but they're a fixed trust with certain conditions, but then they've got a statute that flows over and regulates those. So we've got these, and they've been around for a long time. Some of the key ones that we're probably pretty well aware, and we can fit most of these into that. So we've got the discretionary trust, where the trustee has discretion as to the distribution of capital and income amongst a range of beneficiaries. So most of us know that one. A fixed trust, there's fixed entitlements for fixed beneficiaries. So, for example, a unit trust, if we go into they call them managed funds here in Australia, but essentially, for the most part, they're unit trust versus listed investment companies. But if I go into a property trust, then I've got a fixed entitlement to income and capital of that particular trust. Some trusts aren't fully fixed. For example, where there's a vesting of the trust or a winding up of the trust, which is one and the same. So when someone talks about vesting, they're actually talking about a winding up the trust or bringing it to an end. In that instance, we may have in a true fixed trust, all the distributions have to go to the unit holders pari passu or in proportion of what they've actually received, compared to, for example, just an ordinary unit trust that we have on our platform. And I'll talk about all our trusts a little bit later on, where there's a bit of discretion within there. So you don't use the normal unit trust for a fixed trust for New South Wales land tax purposes, which is considered as a separate entity of its own and has its own land tax threshold. In terms of hybrid trusts, they're a mix, and usually you'll have people who are unit holders, but that unit holder can then direct the trustee to make discretionary trust distributions. So if we have a look there, we've talked about unit trust. As I said, the SMSF is a fixed trust. So you put contributions in, they're then invested, and then you can take your money out at a later stage. It's completely different to ordinary unit trust because essentially, if you consider that Section 19 of the SIS Act basically says that each SMSF, in order to be a regulated superannuation fund, you have to obviously be a super fund to start off with, or a retirement fund or a benefit fund. If you then elect to be regulated, you must have a trustee. And for example, if you've got individual trustees, it has to be for the purpose of old age pensions, so you can't pay out lump sums, etc. So if you didn't meet that condition, so that if it was ever a challenge that you weren't a regulated superannuation fund, which I'm surprised the Commissioner hasn't done in the past, then effectively you end up with a fixed trust that hasn't distributed its income, so hence it'll be subject to tax under Section 97, probably 99A of the Income Tax Assessment Act. So we've got those three core ones. So out of that flows a whole lot of different styles. So if you understand those styles, so there's discretionary, which the trustee has a lot of discretion, fixed, where there's certain rules and conditions about how income flows, how it's proportional down to the unit holders, etc. And then the hybrid, so it's still fixed in terms of income, but discretionary as to where that income goes. So they're our three core, and really hybrid is sort of just discretionary fixed trust married together. One of the big issues, we'll go through and have a look at some of the core terms or some important themes for us. We get this question all the time about set laws. And if you have a look at overseas, so trusts aren't just in Australia, they're very popular over in the US. And for those of you who did our course, you would have seen there's a really great a video there of using a living trust versus a will in the US. It has some very distinct advantages, which is the area that we're all going to be moving into as we go through that innovation early adoption rate. And that's really going to my mind, is really going to change the whole estate industry here in Australia. But we're going to be leading that as a group together, which is very exciting. And over the UK, obviously Canada, New Zealand, Hong Kong, or who knows what happens in Hong Kong anymore, Singapore. So trusts have been around for a long time, and essentially, they're used, as you could see, with the issue of the Crusaders, but also to pass estates from one generation to another. And of course, that's when they brought in death duties. And by passing it one generation to another, there was no death of the trust, that's how the rule against perpetuities came in, because you had to have a death of a trust. Otherwise, it would just go on ad infinitum and we'd end up with death duties. Now, one of the issues in Australia is the generally everywhere else you'd have a settlor, someone who settles property into the trust and can actually be a beneficiary of it, and trustee of it, and an appointor. So that's a unilateral trust. So the only party is the person, but obviously could have other beneficiaries as well. In Australia, the settlor is really a person who is someone that really, sort of stands out from everyone else. And that's because of Section 102 of the Income Tax Assessment Act 1936, and talks about revocable trusts. And a revocable trust means that they can just be ended versus irrevocable trusts. So that the section there says where a person has created a trust in respect of any income or property, when you create a trust and you put property in, you're called a settlor. So you're settling property into that trust. And the person that's a settlor has power, whenever exercisable, to revoke or alter the trust. So they could be a trustee, or they could be an appointor, so as to acquire beneficial interest in the income derived by the trustee during a year of income. So they're a beneficiary, or subsequently go down the track and then they can become a beneficiary, or the property producing that income, or any part of that income or property or income is under that trust in the year of income payable to or accumulated for or applicable for the benefit of child or children of the person who is or under age of 18 years. Commissioner may assess the trustee to pay income tax under this section. So you're actually taxed under that section as much as it would be as an ordinary trustee. So hence, this is one of the reasons that with settlors, we just have someone there who's sort of in and out. So they put in $10, that settles the trust. And then you'll find all throughout the deed, there's a set of rules that basically says, well, hold on, the settlor is not to do this, the settlor can't benefit from this, the settlor can't, be the trustee of the fund, any upgrade can't give benefits to the settlor, otherwise you'll end up being caught within Section 102. So Australia is quite strange in that regard compared to everywhere else, but it's the law, so we go down that track. You can see there's a few little questions, so there's a few chat up there. So as long as Michael and Onusa can handle all those questions, if that's okay. You're best, if you want me to, the chat, best thing to do is if you're going to ask a question, put it in the Q&A rather than the chat, because it's easy for me to follow on the Q&A rather than the chat, and then they will do that. But if Michael can answer all the questions on the way through anyway.
Yeah, I'm handling those ones, but any specific questions, put the Q&A, obviously, as Grant said.
Fantastic. Beneficiaries, this is important. So beneficiary, and this is also the same, unless it's written into the trust deed itself, particularly a fixed trust. And remember, a fixed trust is just a set down. These persons are to benefit in this proportion. We've to make it easier, we've unitized that in Australia. So a fixed trust, I can do a fixed trust that has no units. It's just on a partnership or a percentage basis, but it's very easy to use unitized because we've taken that from the funds management industry. But beneficiaries have no right or entitlement to any assets of the trust. So that's a very famous case over the appeals court in the UK, Gutside versus Inland Revenue. And that's why it's good to see different, you can pick up case law from all around the world around trusts and then apply them just as equally to Australia. And that was applied in Ligon nominees and Commissioner of State Revenue in 2005 and here in Australia. As I said before, and Michael and I were discussing, that essentially the deed is the law. So remember, and SMSF is exactly the same one. So with the deeds, they're subject to equity law, and as a consequence of that, there may be laws around, for example, the Trustee Acts in each state jurisdiction, which will then monitor what the trustee can and cannot do. Certainly doesn't monitor what is inside that trust itself. We might have then other rules, for example, in the Social Security Act, that has provisions in there, and also the Income Tax Assessment Act in terms of special disability trusts. So they'll come in and say, well, if this trust meets these set of conditions, then you get tax concessions. But again, the whole deed itself is its own body of law that is then enforced by the law of equity. So which is one of the reasons that we talked with that analogy that if you're going to go and buy a house, that you really need to, make sure you understand what's in the contract. understand what's in the drawings, and you're getting exactly what you want. I mean, none of us would go and spend $1 million on a property without going through the building contract in fine detail. And the courts are littered with cases where people haven't read contract and gone and done a deep dive in the contract. So again, contract law is different from trustee law. Trust deeds or trust law is a grade, or a deed is more solemn than a contract. You don't necessarily need to have consideration in terms of a trust. So, for example, I can be a beneficiary of a trust or be an appointor of a trust and have no money in there whatsoever. Remember, because it's been settled by someone else. So the deed is the law, and I'd encourage you all to, next time you set up one of our deeds, just spend the time. They're not that long, particularly our discretionary trust deeds, our SMSFs. We've cut it down and cut it to the bones. Go and have a look exactly what the laws allow your trustee to do, allow the appointor to do, etc. Have a look at the process. So the more you know that, again, that helps us innovate, because you might say, well, we want to do this, or it doesn't look as though we can do that. So we can then make changes if need be, and then feedback loop back into you as early adopters. As I said, the rule against perpetuities was essentially designed to ensure that if you didn't have that, trusts and death duties were in Australia up to 1973, and they'll probably come in again at some point in time, that when we have a look at death duties, that at some point in time, obviously on the death of a person, there's a tax on their estate. And of course, we use, and this is what they do overseas, they use the living trust. And that living trust in itself carries on past the death of the person, so that hence death duties weren't applicable. So that's where the rule against perpetuities came in, that only lasts for 8 years. So there was a vesting event, and vesting, again, it's a wind up. So we'd have to transfer the assets from the trust out to the beneficiaries. And then that would be subject to stamp duties and capital gains tax at that time. So again, the only one that hasn't done that is of course, South Australia in terms of the rule against perpetuities. Updating deeds. So the Charles case, and also commercial nominees, and the ATO guideline TD 2012/21 really upturned or overturned the Commissioner's view that any change in the trust deed was a brand new trust and a resettlement of something we learned, virtually, right from day one. But we're lucky we've had very strong courts have decided otherwise, and the Commissioner's had to change the tune, because although Charles's case was a full federal court decision, the Commissioner appealed to the High Court. The High Court refused to hear the appeal. So it doesn't mean that it might not come down the track, but effectively the Commissioner stuck with what he stuck with. So have a really good look at that resettlement ruling. But essentially in that one is provided that you, and this happens with SMSF, in fact it happens with all trusts, I shouldn't say that, when you're upgrading the deed, you have to go in and have a look at what the clause is in, or the mechanism, or in fact, if I go back to point 2 there, what is the law for that deed in terms of amending the deed? In some instances, you can upgrade just one part of it, or you can upgrade 2 or 3 parts, or you can upgrade the whole thing with the exception of certain amounts. So you can do all that through our system as well. So just have a look at that. That's pretty important, because again, if you've got old deeds, really, as a rule of thumb, any deed that's pre-2011 doesn't meet Bamford. So there's virtually no streaming requirements in there. So you've just got to make sure that they're updated. And a number of ones I've seen, I just dealt with one yesterday. They updated it just for Bamford to insert the income. They would have been better off than upgrading the whole amount. You've got to be careful too. I looked at a SMSF yesterday. It was from 2007. That whoever drafted it obviously had no idea about drafting. They just copied and pasted a whole range of the laws around a market link pension, around this pension or that, and the laws, and they virtually took big slabs out of the SIS Act and put them into the SMSF. Good for padding out, but completely useless, because if there's a change in the laws, it now means that the pension you've got in there is not got to be any complying. So again, you've just got to make sure you sit and question who drafts these, because honestly, in Australia, there's not that many people who draft deeds. In fact, when you have a look at a lot of them, they will come from like your average suburban lawyer will pick up something off LexisNexis or from Thomson Reuters, and then they just use that as their system. So, one person has done that, and now that's suddenly spread across everyone. So it's incumbent upon you to have a really good read of the deed. So if we have a look at it, trusts are good for bankruptcy. I'll just go and have a look at a couple of Q&As that I've got here. John Abalone, I've been using hybrid discretionary trust to overcome Div 7A issues with debit loans back to the operating trust. So instead of a loan, the corporate beneficiary buys what I call special income units. Okay, I've seen that. At $1 each in the operating hybrid discretionary trust, these special income units entitles the holder to first bite of the profits to be distributed, if any, equal to the ATO benchmark interest rate. Hence, the SIU converts what would have been a loan to an investment that earns passive interest at a commercially and ATO accepted rate of return. The strategy was validated by 2 tax specialists. You're actually quite right. So it's a separate trust. The Commissioner has given a ruling out on that one, John, so that you're holding it quite separate in there. So it does get around Div 7A. There's a whole guideline on that one. So you are right on the money. If you want to send me an email, then I'll flick you that reference to that, which is something that we will be building when we come around to. I've built my first base of hybrid trusts, so we will be building those a little bit later on. So Paul, has LYD had time considered being the set laws of trust such as ACIS? I could probably, I'm not sure how we'd go about doing that. I'm sure it's not a difficult process.
I did have, I had a look
I know
recently, and we sort of have discussed it briefly, but we haven't really advanced it any further. They effectively, I believe the way ACIS does it, though, they actually are involved in establishing the bank account and then ensuring the settlement sum's paid.
I know that would be the only problem we've got is how to do that. Maybe what we should do. Here's a good one. Let's come up with some LYD coins. So we'll have our own little cryptocurrency, and that way that when it's done, we can have actually that settled as a digital currency. So maybe we could get one of our team to look at that. I think that's.
Do we get to have your face on it, Grant?
No, yeah. I could be the heads, you could be the tails, mate. I think, Paul, that what Michael was saying is that they actually set up the bank accounts as well. Which
I'm pretty sure when I looked into it recently, they do. They set up they're involved in setting up the bank accounts.
Which is a lot of work, because then you've got to, do a 100-point check and all that sort of stuff. So, but look, that again, we're starting to spitball around here. So this is that innovation phase, and I think it's a good idea. Probably a crypto wouldn't be bad. I don't know. I'm sure we can build a crypto so that has some worth. But I'll leave that with. We'll come back to that one. Trusts are good for bankruptcy. So for SMSFs, which are again a trust, essentially they're always protected against the trustee in bankruptcy, excluding pensions. Obviously, they're treated as an income stream. Void transactions, we've talked about all this before, subject to clawback. Like if I put an asset into a trust now, then potentially it can be clawed back 4 years if you've got a solvency certificate. But after a period of time, the trustee in bankruptcy tends to not lose interest, but they won't go and try and claw back because there's quite a big legal process for it. They'll end up just settling for a certain amount of cents on the dollar. So they are very useful for that one, and obviously want to get valuations as well. In terms of income, look, I don't need to spend much time on that one. Most of you know about Bamford, and the one thing up the top there is in relation to income. Again, all the 2011 deeds before that so the ones historically, have always had net income as the distribution point. The reason they did that was because of the Commissioner's ruling in those days that you could only ever distribute income. In fact, Bamford was about distribution of capital gain, and just shows you the Commissioner said that you couldn't distribute that income because in that case, a good friend of mine ran that case all the way up to the High Court. They were distributing, so it was a couple who distributed the proceeds from the sale of a property, capital gain, to Sanitarium, which is the Seventh-day Adventist, and was a not-for-profit or a charity. So obviously it was not taxable. So good old Commissioner took an action against that one, and held that income was just income according to ordinary concepts and not statutory income, which is completely different to everywhere else that he argues it, for example, in terms of non-arm's length income. But effectively, the Commissioner fell foul there. And so we can, now it depends on what our definition of income is, which is really crucial. So we don't want to get caught with net income, because it would mean that, for example, if we've got accounting income that is not net income, essentially we can't distribute it, gets locked up into the trust and then would form part of the trust capital. So we'd have the distributed capital in that instance. Bucket company is very popular, and I know all of us use it. Tim's an absolute lover of it, but if you have a look at a bucket company or distribution from a discretionary trust, if it's business income, then it's going to be taxed at 30% in the company. But if it's passive income, which includes, for example, dividends, rents, all of those sort of things, then I actually saw that as long as you're under the $50 million threshold, it's now 25%, which is, I mean, how do you beat that one, Tim, when you have a look at these rates?
This is a massive one. And look, I have a lot of discussions. I know we've been promoting bucket companies in Change GPS. We have a lot of clients. Look, some accountants go, why would you use bucket companies? You can't get the money out. You can't invest them. You want to buy properties and growth assets, and you miss the CGT discount. I challenge accountants. I think bucket companies are a great way to go with high-earning individuals, and this is why. You maxed out at what you can whack into super, 27.5 grand, unless you want to do some excess contributions. So if you've got clients on high income and are going to be in high income for a number of years, if you've got a business structure so you can funnel profits into a bucket company, why not cap your tax at 25? Use that company to buy investment properties, to buy shares, manage funds, whatever. Because when you get to age 65 or 70 and you want to not work as much, you leave your money in super as long as you can. You've got franked dividends you can pull out from bucket companies down the track. So what's the difference between paying company tax at 25 and then top up down the track, as opposed to having to pull it out from a bucket company and invest in your own name? And you've got Div 7A issues, clients can't understand it. You've got to pay that money back anyway. It might not be taxable, or might not be deductible. It's a whole nightmare, as opposed to just investing in a bucket company, paying your tax at 25, bringing it out later on when you're not paying as much top-up tax. I just think it's the way to go. What do you reckon, accountants?
Yeah, look, just put your thoughts in the chat line there. But when you have a look here, look, I was just blown away that, you know, you're on 32.5 cents or percent after $45,000, which is, you know, that's just absolute crazy stuff. And so it really makes these bucket companies a lot more important. I'd also put it that it's a really good financing tool, that if you've got cash in there and you've got an SMSF, you're quite right, Tim, you can only put so many contributions in, but if you're going to go and buy an investment property within the fund, you can do a related party loan. I mean, worst case scenario is that you're going to be a 70% LVR. But again, if you have a look at the session we did the other day with Gnarly, in the explanatory memorandum, said, well, you go out and find what commercially is available, and then you can replicate that, so that, you know, if you've got someone doing 80% LVR to SMSFs, then you can apply that. So that's a great way of doing it. There's a couple of other sneaky little ones as well. When it comes around to family law, they're not the best. They are good for the second or third generation. And you can see that when you have a look at some of these, like Morton and Morton, McDonald, like McDowell and William, so you can't review a mother's trust, etc. when it comes around to discovery. So that's good. But Kennan and Spry, which was a High Court decision, I can't say it's an outlier, but let's face it, all the judges hated Dr. Spry. So it wouldn't matter. If you had to look at the case, it's, for those of you who got a bent on the law, have a really good look at the case, because the way that they got to the result was really, really bizarre. And it's a High Court decision, so you can't really go against it, but it's certainly a strange set of circumstances that they really overrode a whole lot of variations. They went back to try and target him for a specific purpose. But family law is family law, so you've just got to be very careful about that one. You can, obviously it all comes down to control, but second generation, all that were okay. Family provisions cases, look, great for estate planning. You can pass the control to the family. Again, it just flows down through the appointorship, the beneficiaries, if it's all set up right, and I'll show you what we're doing a little bit later on with that one. But again, it's subject to the vesting rules. I've got one of my team who's doing some deep dive research into with trust deed amendments. We've talked about there's no CGT. In most states, there's also, in New South Wales and Victoria, there's absolutely no stamp duty consequences for making any changes. Western Australia and also, I think, South Australia to a certain extent, or Tassie, it's if you're surrendering the trust, which we're doing a bit more of a deep dive into. So we'll have a look at that, and we'll come back to you on that one. Family provisions claims, it sits outside the estate. The only thing is, in New South Wales, there's a fairly obtuse provision within the Succession Act that allows, if you've settled it within 3 years, or you put the money inside of 3 years, effectively, potentially there might be a clawback there if the intent was there to get it out of family provisions. So it's like all of this stuff, when we're doing all of these structuring, that's really that's the PEPA restructuring style we're doing. You really need to do it now, so it gives you that time to spread, so you don't have that family provisions, you don't have that Bankruptcy Act issue. So let's go through and have a look at discretionary trusts. And what I'm doing here is I'll just go to the Q&As before I go into each of our trusts. Okay, so Michael talks about the hybrid, which is great. Actually, that's a really good one. So Michael, now it's 25%, even 100% CGT applicable. Yeah, you're quite right. It's a pretty good point we're doing there. Okay, so just confirm with another account who uses ACES, they put $10 cash with the trustee. Okay, so Paul, we can do that. We're about to, once we launch LYD2, you'll be able to get a set of documents from us. So we've organised that process. So that's how ACES do. So what we'll do there, if you can remind me, Paul, that where you have that printing option, then we can go as set law, because
it's still a strange and very archaic way to do things, is to attach $10 into a trust deed and send it out. I think they grant, like, I mean, yeah. Cash is dying, and it just seems strange to me to do that. And also, you know, with viruses and stuff, I wouldn't really want to be passing cash around.
Yeah, well, actually, I think we could probably up the ante, and why don't we just we'll come up with our own digital currency that we can do that, which would be good. So again, innovate, and we'll see. John Stitt, bucket companies for bloodline, absolutely, that sounds great. So John Apolloni, where you have a trading company owned by a trust, the new bucket company is the company inserted between the trading company and what was the holding trust. 100% of the shares in the interposed company is owned by the trust. Actually, I'll have a look at that one a bit later on. It sounds a really good strategy, but I've got quite a bit to go through, so thank you very much for that. Okay, so Daisy, I've just banked the settlor's money and recorded as a settled sum. Yep, that's a good idea. Okay, so I'll come back and have a look at that one, John, a little bit later on if I can get that. So it's good. And this is why it's important, John and everyone else, if you do hear of strategies or ideas, come and send them to us, because we've all taken brilliant advantage of the protector. And I have to thank Tim for that, because he said, look, you know, I'm paying X amount of dollars for this and I'm hardly making any amount on it. So this is the sort of strategy that's involved. And I had it right under my nose all the time, because we had deeds of gift and promissory notes and stuff like that, which enabled us to actually build it and then develop further on from it. So again, come to us with any ideas, strategies, or anything that you hear on the ground, because we're very good at building, innovating, and creating an even better product. So in our discretionary trust, I'm going to go through all the LightYear Docs just so you understand which one is which, and I think that's pretty important. So in our discretionary trust, you've got a wide open, sorry about that little typo about distribution, it's supposed to be closed brackets, but income is essentially up to the trustee. But if a trustee doesn't make a determination, which usually comes through the distribution. So for those of you who use our distributions, which is really important to get all your to the best extent possible, all your discretionary trusts on the LightYear Docs system. If you don't want to go through the upgrade yourself, we've had a couple of accounting firms getting Abbott-Family to do bulk upgrades for them. It's not an expensive process. You'll still make money out of the whole deal, but at least you got, it's off your plate. You don't have to do any work. You've got everyone on the same system. So when you come around to doing trust distribution resolutions, you know it's going to fit in with the laws. Because you can't do a trust distribution resolution to distribute accounting income that's not net income if your deed only allows net income. So we want to make sure you get all of that. And if you're interested, obviously just contact me directly. So with that one, what we're doing is from that perspective, we want to get, we've got a wide open income, but if there is no distribution resolution potentially, then it's to be treated as net income, because you don't want the net income left within the trust. Principal beneficiary, you name the principal beneficiary, can include the spouse of the principal beneficiary, and then it goes down to children, great-grandchildren, companies, SMSFs even. We've also got other trusts as well as charitable bodies. You can also add beneficiaries going down the track and delete beneficiaries as well. That's really important when it comes around to doing family law court orders, which we've just had to do a few of those at Abbott-Family. Capital, the trustee can set aside the capital in separate trusts for different beneficiaries. You just got to watch out though, if I take a property out of the trust and put it into a separate sub-trust for an individual, that again, it goes down to that settling. Have I taken that property and settled it into a separate trust? So there is actually a brand new trust. And so therefore is capital gains tax consequences. You can see that within the ATO guideline, that TD 2012/21. So, but if it's just a sub-trust under the same trust with different assets, etc., so we haven't settled it quite separately, then you'll be A-OK in terms of capital. In our appointors obviously the person who controls can hire and fire the trustee. So you can add a succession, a line of succession or appointors. You need to go at least 3 levels down. If you haven't put in a succession of appointors inside a deed, it's probably incumbent either upgrade the deed, or you can go onto the LightYear Docs site. You'll see there's a document. Again, just go to search and it says succession of appointors, so you can add extra appointors there. But you need to go back into the rules to see how you can actually add appointors, and generally it's appointors who will add. Trustee, you can use a company. We've got a special purpose discretionary trustee company, which doesn't pay divs. So it really, its sole purpose is to act as discretionary trustee company, and it's built in a whole lot of processes in there for what happens on death or incapacity. And again, it's a good one. Those ones also have successor director solutions in them. As we see there, the appointer can appoint and remove the trustee. In terms of the leading member, it's based on the discretionary trust. So so what happens, you start with the base and then you build on top of it. Now, there is no principal beneficiary, because what happens is the leading member appointor is the principal beneficiary, and then includes all their bloodline. And we've had a couple of questions. Well, what happens with bloodline? So I've put in a definition you'll see very shortly. Capital, again, can be set aside for one or more beneficiaries. So we flow that on. But what we're building, I'll come to this a little bit later on, is that you'll be able to build sub-trusts with their own terms and conditions in there. Again, we'll make sure that there's no resettlement issues there. so that it can pass down from generations to come, so that the whole family can have their own little nexus within that original trustee. The appointor is obviously going to be the leading member appointor, so there's not much difference between the two. One of the big differences, you really must use a leading member discretionary trustee company, because what happens there is then the shareholder for the leading member trustee company needs to be the leading member appointor, because what happens on bankruptcy, death, incapacity, or family law, or resignation, or if they're charged with a crime, effectively their shares are cancelled, and then the new leading member appointor comes in. And that's the good thing about that, is then we're working in two levels that they both work seamlessly together, so that if that leading member appointor is attacked, they can bail out of there really quickly, and then it moves the whole trust or control of the trust down to the next level. Okay, bloodline. So this is a new definition we're about to put in our original deeds. We didn't have this, but a couple of people said, well, we'd like to know what the definition is. So we're going through quite a large revamp of our trust documents. I went through them the other day. So in terms of, for example, the non-foreign beneficiary or the non-foreign person in the trust, rather than having separate ones for that, you'll just be able to tick a button depending on what state you're in, and then up will come clauses within that, much like our investment strategy. You tick and a whole range of new clauses come in. So that'll make it a lot easier for us. With the bloodline, includes, so bloodline, when you see a definition says include, so there's a difference. Bloodline means if a bloodline, that is the definition, you can only have that definition. Bloodline includes means there's obviously a common law definition, a general understanding of what is bloodline, and as a consequence of that, it includes a person's child or their lineal descendants, and obviously we'll understand lineal descendants. And if you're going down this bloodline track, this leading member track, again, you're really going to cut through the clients, really take a client from 0 to 80 kilometres an hour in virtually seconds. If you start to say, well, this is how the British royal family works, you've got the Queen as the leading member, then the next, and the next, and obviously the only people who can pass out as a bloodline. And I think Michael sent me through quite an interesting article the other day where old Harry's stuff has been binned. It's gone over to the Duchess of Sussex. So again, it's kept within the bloodline, because although Harry is bloodline, he's now persona non grata. He's effectively been written out as virtually a beneficiary of that family hierarchy. So, which is quite interesting. So again, but we can see there can be any child deemed to be a bloodline by the leading member appointor. So dwell on that, and if you think there's a better definition of bloodline, come back to me on it, and we can have a look at it. In terms of the family protection trust, honestly, it's just the same as the leading member trust, but you're going to see in there it's not a leading member appointor, it's a family protection appointor. I built that up just as a different name. I'm not really sure whether to keep it or not, whether it's too confusing, but we do put that within the within the protector. You have the ability to set up a family protection trust, but I'll take it off you again. We're very, we're very feedback intensive. Our estate testamentary trust. Generally you'll see within when you go through the wills, for those of you building wills, I did some today with Kushru Dastar from Prime, who's been building some great wills, and he's built some testamentary trusts. So you can either have optional or you can have mandatory ones, and you can start to put terms and conditions in there. We're going to start to build that a lot more detail, so that when you go to probate, what happens, you'll have the will, and Tony's unfortunately out for a big lunch, so he's not available today, but he's the guru around administration and probate. So that when we get to that position, we go to the Supreme Court to get probate, we'll need to have a testamentary trust created that has to have at least those terms and conditions in there. So that's a good thing to have. So we have that testamentary trust that's created. So between the time of death and the time for application of probate, you'll draft up a set of documents, or you can get Abbott-Family to set up a draft of documents. We'll be releasing that a little bit later on, and then that gets attached to probate, and then we're off and running. And then what happens after that, the executor then settles that testamentary trust. The alternative is you can build, and I've talked about this before, you can build a full-scale testamentary trust, which I see quite a lot within the will, pads out the will a lot. And if you can think about it, if you can think, let's say there's 3 testamentary trusts for 3 children, so you're having separate testamentary trusts and you're doing the full-blown line out, then it's like having 3 of our leading member trusts built within the will. So suddenly your will is going to go from maybe 5, 6 pages to 100 pages or so, which is not a bad thing. But then again, you are limited by, when you go to probate, you have to have those specific trusts. So what you'll do is you just take those and you have to replicate them exactly, although you do want to make sure there's a good amendment clause in there, which there is. Then you go to probate. So either or, my preference is to obviously do more terms and conditions and then build the trust between death and probate, but you'll have both options. But that, before we launch that, obviously will come out. Again, the principal beneficiary is the person who's going to be nominated for the testamentary trust. The capital can be set aside for the beneficiaries or one or more. Quite often there'll be limitations on capital there because they're going to be, for example, for children. So they might not be able to access capital until age 25, unless it's for education. The one we saw with Korshitz, unless it was for a master's degree or for purchasing a home or doing something else. So you get, or health. So you can put all those in, and then once they turn 25 or 27 or 30, depending on the parent, in some instances, no access to capital ever, which is if the child looks like a spendthrift or drug addict or whatever. You can even write in their terms and conditions that before they get any distribution, they're to have a drug test or whatever. So the appointors, quite often, it will depend on what it is. If it's a smart child or a smart person, they could be the appointor, and you want to do that succession of appointors again. But if it's not, then you might have the executor as the appointor and the executor as trustee. So it depends on who the beneficiaries are, or who's going to benefit out of it. But all of this, the testamentary trust comes from a will. But as I said before, in terms of family provisions claim, because it comes from a will, it's subject to a family provisions claim. So you might create this trust, but if the estate has been whittled away by legal fees and also other specific gifts, you might have a testamentary trust that might be for like $5,000, which can be a very expensive process, because if it's inbuilt in there, so if it's mandatory, you have to build it in order to get probate. In contrast, what we've got there is an SMSF death benefits testamentary trust. Now, this comes from an SMSF will, which is a binding contract between the trustee, SMSF trustee, and the member. So what will happen there is within that will, the dependents, which includes adult children, and doesn't mean, and financial dependents, so if a brother or a sister or whatever, and we've been through all those financial dependency laws. Essentially what can happen there is the trustee can settle the death benefits into that trust, and we need the trustee to do that, so it's not akin to, we don't get caught up in section 102 we looked before. So we transfer those benefits into trust. Same thing, all the testamentary terms and conditions. It's just a little bit different from our standard testamentary trust that goes through the estate and potentially subject to a family provisions claim. The principal beneficiary must be the dependent, and also importantly, on any vesting or winding up or payment of capital out, it has to go to that dependent. So it's very akin, for those of you who know, to a child maintenance trust, where you can settle property into a child maintenance trust, which is another trust that we can build for you through Abbott-Family. That child maintenance trust, you settle property in, and then effectively from that perspective, that can be then distributed to children, and they can be used as child support, but they're taxed at adult tax rates. So it's very, very beneficial. Again, the appointors is going to depend on what you put in the SMSF will. We've left ours pretty open to, if you have a look at an SMSF will, the executor has the choice as to who the appointor is and the trustee and so on and so forth. So again, it just depends on whether you want to go down that track. But that sits quite separate from the testamentary trust and is covered under Commonwealth law. So it doesn't get caught up in a family provision claim, except potentially in New South Wales. Unit trusts. So fixed or semi, we've got a really good unit trust there. Can be used for syndication. If you need it tailored, particularly if you're doing a syndication, rather than having a unit holder agreement outside of Abbott-Family, we can tailor it so it's bespoke, and depending on the size of the syndication, we can build all the unit holder agreement within the unit trustee itself, which is just a lot stronger, I feel, personally, mainly because then you not only get you've got equity law as well compared to unit holder agreement, which is just common law or contractual law. In New South Wales, fixed trust. So our unit trust on vesting, there is some discretion as to where the capital goes. Essentially, it does go out to unit holders, but there is some flexibility to say by the unit holder as to where they want it to go. Whereas in the New South Wales fixed trust, it has to go to the beneficiary or the unit holder. And that's in order to get that land tax threshold. So make sure in our stuff you use the New South Wales fixed trust. The suit is again, based on our unit trust product, which again is a fixed trust. However, it's got I've put in a lot of terms and conditions around the superannuation laws that are embedded in there. Obviously, if you go above the 50% threshold, then it means that unit holding is an in-house asset for you, and they can create quite a few dramas, not huge dramas, but quite a few dramas, which would then mean from that perspective is suddenly all those units are obviously going to be in-house assets, and then you have to put in place a plan to divest that amount that exceeds your 5% threshold. So if inadvertently you go above that 50%, then it's held in a trust within the trust. So we've put a few little safe breakers or fail-safe breakers within there. 1322C trust, it's okay. It's mainly for SMSF, for using it where you can use, for example, joint ventures on investments, or you're buying a residential property that ultimately is going to end up in the SMSF. So you can buy it through the 1322C trust. Obviously, they can't have any borrowings on it. You can't use shares. It's generally for things like artwork or property, etc., like that. And then essentially, or Bitcoin, for example. And then what we can do is we can then transfer the underlying units into the SMSF. So ordinarily, if it's a private unit trust, you can't transfer units in if they're a related party, but you can with the 1322C trust. So that's quite a useful one, and that's sitting on our system as well. Appointors, well, usually the appointors, there's no appointor. What happens is the unit holder is the appointor. The settlor of the trust is generally the unit holders when they make a contribution in there as well. A trustee company, I just use a standard company. Just be careful with suit that up at the board level, you don't just put, for example, the one, I've seen this in the past, that the SMSF investor had 50%, someone else had 50% who wasn't related. But then one of the members of the SMSF was the only director of the trustee company, which meant that they really controlled the trust, and hence all the units were in-house assets. So you just got to be careful there. So I'm getting towards it. So new trust on the horizon. I'll just do these and then we'll come around to looking at some questions. So the hybrid trust. So with John, we're talking about that special income units. Tony sent me some stuff on that one. So I've built the hybrid trust. In fact, I think I showed it maybe a month or so ago. The only issue that we're facing at the moment is that we're moving from one platform to another platform. So our developers are busy taking the templates and taking them from one system, Hot Docs, to our new system. So they're really stretched as to what they can do. We sort of hit our limit on what we can put onto our system. So the hybrid trust will have to hold over until our LightYear Docs 2, which will be hopefully in the next 3 or 4 months. So it's progressing pretty quickly, in my understanding anyway. Are you there, Michael, or Mr. Jeffries? Because I know Michael is in there.
Yes, I am, Grant, sorry.
Yeah, so LightYear Doc 2, have you got an estimate again? I mean, sorry to put you on the spot, but...
Yeah, we're fairly well advanced. I mean, Emmanuel is putting the first documents up there at the moment. I was talking to him this morning, and so I would think end of October.
Yeah.
Yeah.
That's good.
If not sooner, we should be operational before then, I believe. But have everything up there. We do have a substantial number of documents, obviously, to get up and then start getting some of the new ones, and obviously go through some testing. We'll do some user level testing with some of our big LightYear supporters, and before we actually take it live. But it is fairly close, Grant.
Yeah, fantastic. And John said he drafted up a bit of a document a while ago. If you want to send that through, John, in relation to property development and splitting units, that'd be fantastic if you could send that through. Principal place of residence. I've drafted up a document there that we can buy a property in a effectively leading member trust and then have a long-term peppercorn lease, like for a 49-year lease with a quite a large surrender value, obviously, for it in the event of sale, such that surrender payment is not subject to capital gains. So that will make quite a big dent in any principal place of residence. I have seen like a housing trust that's been floating around. I know Tim sent me some information on that the other day, and I know a couple of others there. So the more information we can get from it, I'd like to dig in there. That living trust, as I said before, is the leading member trust with those sub-trusts. So we are building that. So you'll actually be able to build it within those sub-trusts at the outset, a set of schedules as to how each of those sub-trusts is to be run and maintained. So I'm building that with Tim very shortly. I think he's got me doing about 26 of them. And of course, we've got a special disability trust as well, which enables distributions from the estate, or alternatively, even from super, to settle into that special disability trust. And that's has a good threshold from an assets test point of view. So special disability trusts are great, but they're limited on when you can put money in. But we've got one of those on the back box as well. Of course, we've got a whole range of SMSFs, which are again a trust, and will be leading more into the future. But from our perspective, trusts are the way to go. And as you can see, we're almost like the home of trusts. I don't think anyone has got such a wide variety of trusts, and all built for different purposes. But we'll continue to build that because, again, if it was good enough for the Romans, God, thousands and thousands of years ago, and still stood the test of time, then we can start to bring it up to modern life, which is important. But look, I'll just any issues or anything you'd like to do as closing comments, Michael?
I actually love what you just said then, Grant, and calling us the House of Trusts, and we probably should put that out on social.
Yeah, well, look, there you go on you. So we're the House of Trusts. So come up with a good graphic of that one.
One of the comments I did really love in the chat was Matt Gill said that post at Pepper, he's already made $35,000 in revenue.
Fantastic. Look,
what he learned in the St Pepper course. So how good is that?
Well, I mean, the whole course, it was, and that's why we do these. That's why we do all these sort of events, is to make you really comfortable, make you confident about what you're doing. And once you've gone through the St Pepper course, you've got that background, so you know what to talk about, you know how to talk about it, and it makes a fundamental difference. So, well done on Mr. Gill there, making $35,000.
And a big win for his clients as well, Grant. So
yeah, exactly. And once you started, I mean, the thing is, you don't need to go out to. I mean, the classic maxim is that your best clients, your existing clients, because it doesn't cost you anything to acquire them, because you've already acquired them. Smart-wise, and Michael and I have been talking about this down the track, long term, there's really good opportunities for, once we've gone into our existing businesses, to acquire other practices and split out the accounting, tax, compliance side from the SPEP side, so that we have two completely different businesses in there. And you'll find that the payback will be about, I believe, probably around about 3 to 6 months in terms of that, particularly if you're using vendor financing. So, that's something over the next 3 to 4 years that we'll be exploring, so that, we really like all of you to come across come along with us on that journey, because we're all in this together, and we'd like to all move and all have the same deeds, all have the same documentation, all have the same systems, so that if we ever decide to IPO or list, etc., that we can all be part of it. So there's nothing to stop us from that, and I think that that's really crucial. It also means that we've then got the opportunity, as I said, to go out and buy practices. Kerry's come in, other sub-trust, mirror trust. We can do that one, Kerry. That's a really good idea. And when I draft it up, I might send it to you, because I know you've got lots and lots of experience around all this sort of stuff. Tim, what say you? Have you got any kind words for everyone there, and want to talk about your session? I saw one of your sessions on Monday about those uncomfortable discussions with clients, and one of the big uncomfortable ones is when the commission comes knocking because your trust deed, and honestly, we're seeing a lot coming through now through Abbott and Morley, whereby banks are going back, and of course, anyone who's doing finance through trust, the banks are going to go through with a dose of salts, and they want to see the original deed. So the number of lost deeds we've had to do in the last few weeks is really important. So make sure you clean up all your deeds first, otherwise you're going to get in quite serious problems.
Yeah, 100%. That's such a key thing. We're finding that as we take over clients, deeds are lost or missing. Even so many deeds that are not signed properly when we take over new clients, it's insane. So let's just make certain you go through all your clients, have this as a goal for your client service coordinator. Go through, scan all the trusts, upgrade them all to leading member ones, the LightYear Docs. Talk to Grant and the team about getting replacement deeds if you need to. Yeah. And just have everything ready for a smooth tax planning for 2022. One deed, one definition. I know you and I'll talk about, we'll combine forces, make certain the trust distribution resolutions are just spot on and simple. And we've got a few things we're already adding into tax planning for 2022 using Change GPS. So I think when you've got the new version 2 of LightYear Docs out there, we will combine forces and make certain that everything's just smooth. The Change GPS to give you the front end to monetize the value of what you do with your clients, LightYear Docs to the back end and push those docs out.
Yeah, fantastic.
Laura's just dropped the link in for the webinar on Monday. I'll make sure I'm on that one. So.
Yeah, it'll be good.
It's going to be a lot of fun. We've got some really interesting, how to deliver bad news to a client. When a client says, I want to do my own ASIC work, what do you say? All the crazy rubbish.
That happens a lot, doesn't it?
Yeah. Oh, I tell you. And so we're actually going to get my wife, Lyndall, who handles this, and Gemma, our client service coordinator. They're going to come online and join us and tell some of the crazy stories. Because Lyndall, she gets really, really angry with this sort of stuff because clients think they can do it and they can't. They screw it up all the time. But how do you explain it to your clients? And even if the client does want to do it, how do you de-risk yourself? Come along on Monday. You'll enjoy it.
Actually, what I might do is I might, because we've obviously got NDA and confidentiality agreements up on the system, I might even put an indemnity agreement up there. So you can put in the client's name, what the strategy is or structure or whatever they're doing. And then they provide you with a full indemnity for that, which would be quite
great. Great idea.
Yeah, so that way you can just rip it out, put it in front of them and say, okay, that's okay, go and do it, but just make sure you sign that because I can't be held to be liable.
Yep.
I've got Marty here. There's a couple of good ones. Fixed unit trust with 3 unrelated unit holders and corporate trustee, only 1 unit holder, shareholder and director. So there's no problem with that unless that shareholder and director is obviously a self-managed super fund, because then you'd be seen as controller, but otherwise it's okay. And good old John, who's the guru of trusts. He said, well, house of trust equals hot. So I think
love it. Absolutely love it.
I think that's perfect. Anyway, guys, we'll see. I think our next we'll make sure everyone's there on Tim's event next Monday. And Michael, you've got a session next Thursday, which is
next Thursday is with Warren from BGL. So we'll be looking at all the different products and everything. So
okay, guys, have a good weekend and enjoy the rest of the week.
Thanks.
See you from Lockdown City up here. Okay. Bye.